The body of Senior Advocates of Nigeria, BOSAN, has called for a constitutional court which will have unlimited jurisdiction to determine all cases relating to interpretation of the 1999 Constitution, enforcement of fundamental rights of the citizens, determination as to whether any person has been lawfully elected into any office from the president to the state governors and members of all the legislative houses. Adeboyega Awomolo, Senior Advocate of Nigeria, made the call on behalf of the Senior Advocates of Nigeria on Monday in Abuja, and Maliki Duro has more.
At the 2022/2023 legal year ceremony of the Federal High Court headquarters in Abuja, the Senior Advocate of Nigeria, Adeboyega Awomolo, said the proposed constitutional court should be established because the Federal High Court is overstretched with so many cases, resulting in normal cases inevitably suffering adjournment, thereby frustrating good and urgent cases.
Political disputation arising from lack of internal democracy, political shenanigans, and impunity in the management of political parties as one that will interrupt this court from doing its constitutional duty. Your Lordship, my Lord the CJ, you call it disruption, and I agree with you. Normal cases inevitably had to suffer adjournments, thereby frustrating good and urgent causes. With all humility, we have reached a stage in this country when very urgently Parliament, judiciary, and all stakeholders in the administration of justice should consider establishing the National Constitutional Court of Nigeria.
Speaking earlier, the Chief Justice of the Federal High Court, Justice John Toho, said the additional jurisdiction conferred on the Federal High Court by the Electoral Amendment Act 2022 by virtue of Section 29, subsection 5 and 84, subsection 14 of the exclusive jurisdiction is foisted on the Federal High Court in hearing and determination of pre-election complaints.
In the hearing and determination of pre-election complaints. Linked to that jurisdiction is Section 285, subsection 10 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, which provides that such pre-election cases must be concluded within 180 days from the date of filing of the suit.
While lending their voice, the Attorney General of the Federation, Abubakar Malami, who was represented, and the President Nigeria Bar Association, Yakubu Michael, has this to say.
Your Lordships have also been called upon to advance the course of our electoral jurisprudence and strengthen democratic practices. While this is evidently taking a toll on the court, it is, however, gratifying to note that the leadership of the court has shown commitment and determination to manage the situation optimally through the issuance of the Federal High Court Pre-Election Practice Directions 2022 and the constitution of a special task force of honorable judges to speedily hear and determine all pre-election matters before the court.
Some of the challenges that will be confronted by this court is the tendency of aggrieved litigants to take to the mass media to insult and denigrate the courts, the judges with uncomplimentary remarks about any judgment that is not in their favor. I had cause recently to call out a senior member of government who, while speaking to journalists, had referred to a particular judgment of this court as kangaroo judgment. My Lord, like I said, at the commencement of the legal year in the Supreme Court, we have already put together our papers. We would sue that government official and request the court to hold that such a person is not fit to hold public office, because to make the sort of comments that were made by such an officer is to incite the public against the institution of justice.
By reason of the new Electoral Act 2022, signed by the President in February 2022, the Federal High Court is designated to resolve all political matters arising from the political party's constitution and their guidelines.